Angela Wanta. All right. So as a reminder, just ask questions at any time. We are going to be going through the listing contract today. And we'll do this in two parts. So I'm going to we'll do the first half today, then we'll finish up next week, Monday. Ideally though, you're not taking 2 hours to explain the listing contract when you're presenting it to a seller, right? So, we'll kind of go through this like in a deeper dive, but then also after each section kind of go through ways that we can say it in layman's terms to a client, right? So beginning at the top, we've got residential listing contract, exclusive right to sell. So for the term exclusive right to sell, that means that no matter who procures the buyer, whether it's our listing firm, a co-broke listing firm, a co-broke firm, whether the seller brings the buyer themselves or finds a buyer themselves, we are owed the commission, and all clients will run through us. Any offer written will be presented through our firm. So the difference between an exclusive right to sell on the flip side is a non-exclusive right to sell, where a client or where the seller might have the option of working with another listing firm to bring a buyer, procure a buyer, and then they would owe a commission to that firm. Under Keller Williams full brokerage company, we use exclusive right to sell. Okay. Seller, line 1, seller gives the firm the exclusive right to sell the property on the following terms. So beginning 2 through 5, we will describe the property here. So the street address goes right there on top. Then on line 4, you will continue on with the municipality type. City of Milwaukee, and then county that the property resides in. Included in purchase price. So seller is including the list price, including in the list price all of the property, all fixtures not excluded on lines 12 through 14. So here you will put personal property like appliances, washer and dryer, anything miscellaneous. Like a big example could be bathroom mirrors that aren't necessarily attached to the walls, but they look like they should be because it fits in with the space really well. They might include those. If you want to be explicit about shelving, that might be included. Whereas, again, a fixture is anything attached to the wall. But if you want to be explicit about something that would be included, I would just be on the safe side and name it here. So as an example, not included in the list price. So again, making sure that we're clear about anything that might not be included that a buyer could possibly think that is included. So we'll go back to those fixture items. A big example I would think is TV mounts and the TVs themselves. So there's always a question about this. It is now determined that a TV mount is a fixture and would remain with the property. The TV itself is personal property. And the seller would take that along with them. But I would again be explicit here if the seller does intend to take both the TV and the TV mount. It's better to have all of this clear, because what you're then doing as a listing agent is taking this information and loading it into and denoting that's in MLS under inclusions and exclusions. So a lot of arguments as it relates to inclusions and exclusions. So I think the more explicit, more clear you are, the better. Does anybody have questions about that? Okay. Line 15, caution, identify fixtures to be excluded by the seller or which are rented and will continue to be owned by the lessor. So making sure that water softeners, for example, if you are listing a property with a water softener, asking the question of the seller, is this owned by you or are you renting this through another company? If they are renting it, then we need to make sure that we're not including that in the list price and making that an exclusion. So in practice, my process is, when I'm going through and doing that walkthrough with a seller, kind of getting those inclusions and exclusions out of the way when I'm doing that home walkthrough, just like room by room, and pointing out like, oh, you've got shelving over there. Is that something that you want to make sure that you take with you? If not, we got to make sure, if you do, we got to make sure that we A, remove it now, or B, that we're listing it in the inclusions and exclusions list. So typically we've got this list kind of out of the way before you're covering the list or going over the listing contract with them. All right, list price. So on line 17, you'll identify what you guys determine the list price to be. In my practice, it's actually usually the last thing we're talking about. We'll go through the rest of it and then we'll circle back on list price. Marketing, lines 18 through 22. So seller authorizes and the firm and its agents agree to use reasonable efforts to market the property. Seller agrees that the firm and its agents may market seller's personal property identified on lines 7 through 11 during the term of this listing. The marketing may include, so things that you can, or examples of what you might put in here are the ways that you are going to market the property. So, media, open houses, to agent networking, print ads, etc. Another thing that I have seen, instead of going through and listing each way that you are going to be marketing this property, as part of your listing presentation, you're going to be going through and detailing your marketing plan. So, and identifying to your clients what your marketing plan is. So a quick way to shorten that all up is, in my listing contracts, I'll say Attorney and Associates marketing plan. And we'll have already gone through, because presumably you have gone over your listing presentation before you've gotten to this point.
I have a quick question.
Yes.
So when you just said that do you then delete everything above Sweeney and Associates and just say we talked about it or not in a nice way? Okay.
Yep. So that's what I would do.
Perfect.
So, another thing that you don't want to put yourself in a position where you are going to be forced to do something that you've listed in your marketing plan that you're not really ready to do. Is a big example would be open houses, where if you wrote weekly open houses, you have to be prepared to do a weekly open house for them, so I would just, again, kind of lump it all up. That's the way that I have evolved that. Any questions? Any other questions? Okay. Lines 22 through 23, the firm and its agents may advertise the following special financing incentives offered by seller. So this, in our market, we haven't needed to do this. In like 2010, 2011, there were a lot of seller incentives being offered, meaning to help procure that buyer, to get them to write. Sellers were offering bonuses to agents, or closing costs could be offered here to a buyer. Again, we're not in that kind of market, so we'll revisit this when we are again, inevitably. But if you wanted, if a seller wanted to offer another incentive to a buyer, you could note that here. Line for the seller. Seller has a duty to cooperate with the marketing efforts of the firm and its agents. See lines 246 to 252 regarding the firm's role as marketing agent. Seller agrees that the firm and its agents may market other properties during the term of this listing. So, just a checkpoint to say to a seller, you're not the only listing that we have. Commission. The firm's commission shall be, and this is where you will put in the percentages. Everyone has their own way of handling how they want to present commission options, or an option at all. But, as listing agents of this company, you can go down to 5% and not seek or not get permission from one of us in order to do that. So if you are wanting to charge 5% or less, again, you need to come to us to get permission to do that. But between 5 and however much you want to charge, you are free to do that. So just a quick tip, a lot of times agents will just put in options here and have sellers circle which option they want. I leave it at 6%. And then if there's discussion, if there's pushback, then at that point, after discussion, we can think about going lower. But, I'm always pushing for 6%. The 295. So again, in our independent contractor agreements, as listing agents, we owe a $295 fee back to KW. More often than not, agents are just using this as a pass-through, using the commission line as a pass-through, to make sure that it's covered automatically. That 295, again, if you left it at the 295, it would be just a strict pass-through. But I've seen agents who have tried and successfully gone higher. So that 695, 295 will be taken out of it. And then as the listing agent, you can keep the remaining $400. Like J. Schmidt Group, I know charges $695. I charge $395. Usually I'll see it between $295 and I think the highest I saw was $795. So. Commission earned. So this outlines, the next section outlines when we as a firm have earned our commission. So seller shall pay the firm's commission, which shall be earned if during the term of this listing, 1, seller sells or accepts an offer which creates an enforceable contract for the sale of all or any part of the property. So typically what's happening. 2, seller grants an option to purchase all or any part of the property, which is subsequently exercised. Seller exchanges or enters into a binding exchange agreement on all or any part of the property. A transaction occurs which causes an effective change in ownership or control of all or any part of the property. Or a ready, willing, and able buyer submits a bona fide written offer to seller or firm for the property at or above the list price and on substantially the same terms set forth in this listing and the current WB11 offer to purchase, even if seller does not accept the buyer's offer. A buyer is ready, willing, and able when the buyer submitting the written offer has the ability to complete the buyer's obligations under the written offer. So, when we are enforcing this, obviously a number one, seller sells or accepts an offer, which creates the enforceable contract. So that's, 9.9 times out of 10, that's what's happening. I'm going to go straight to point 5. And we as a listing firm have gone back to sellers and have, enforced this concept of wanting to collect a commission, even if the seller does not want to sell after they have received an offer with pretty much the same terms that the seller has outlined in their listing contract. So we had an example a few times this year where a home was listed and a buyer came forth with an offer at or above list price, and then the seller did not want to sell. And we had conversations back with them that they could potentially still owe us a commission if they did not go through with it. And that, either prompted them to go through with the sale, or we worked something else out. It's very rare that we, as listing agents, are going to enforce a commission. But just know that if you are in a situation like the one described in item 5, that we have had conversations with sellers on possibly owing it. So I was going to bring up, last time we had this listing contract training, Joni pointed out how many times if a attorney is reviewing these listing contracts, usually lines 31 through 40 are completely crossed out. Yep. And the only time that the firm can collect a commission is if the seller accepts and closes on a sale of the property. So firm's commission shall be earned if during the term of listing one seller of the property sells, conveys, exchanges, or options as described above an interest in all or any part of the property to another owner except by divorce judgment. So in practice, I'm not going through each one of these points. I'm letting them know that commission is earned and paid at closing. Once, commission is earned once we accept an offer, is paid at closing. My personal business practice, I wouldn't, if something happens with the transaction and it falls apart and the seller wants to get out and pull their home from the market, I'm not going to enforce, a commission. So, Joni, do you have any comments on that? Have you ever?
Just a few times, and it was basically where the seller was not acting in good faith. I mean, they weren't honest with the situation. They were trying to pull an end around. And when we saw that, we went into this listing contract in good faith on both sides. And when we saw that the seller was lying and not acting in good faith and trying to capture a buyer without paying commission and all this sort of stuff, we definitely enforced it and won.
I guess it's all case by case. So the point is just making sure that you come to Joni or I, or if you have gut feelings about how your seller is acting, or not even a gut feeling, just how they have presented themselves. So, yeah. All right. Commission is due and payable. Once earned, the firm's commission is due and payable in full at the earlier of closing or the date set for closing, even if the transaction does not close, unless otherwise agreed in writing. So kind of back to that, if it doesn't close, this is outlining when that commission would be payable, but back to what we were just saying, if it's something that we're not going to enforce, they're not going to be paying it. Calculation, so a percentage commission shall be calculated based on the following and or and above under 1 or 2, the total consideration between the parties in the transaction, the list price of the entire property, if the entire property is involved, the exchange involves less than the entire property, or under 4, if the effective change in ownership or control involves less than the entire property. Okay, fair market value. 5, the total offered purchase price. So I'm just gonna go straight to 5, Mr. and Mrs. Seller. The commission is based off of the purchase price times the commission amount. Compensation to others, so lines 52 to 53. So the firm offers the following commission to cooperating firms. So in our marketplace, 2.4% to the co-broke is what is common. Many times, and I think this is probably the easiest, but when you are going through this commission or going through the listing contract, having this 2.4% already spelled out, in addition to the 6% up here. So you can kind of just like have the one big conversation about the commission, the total commission, and let them know that this 2.4% is coming out of this 6%, and it's not an additional commission to a buyer's agent, is all encompassing from that, or it's all coming from that same 6%. A lot of times agents have felt it's easiest to explain it best that way, and easier than for you to have a conversation about the full 6%. Any questions about that? Okay. Buyer financial capability. So the firm and its agents are not responsible under Wisconsin statutes or regulations to qualify a buyer's financial capability. Seller wishes to confirm a buyer's financial capability. Seller may negotiate inclusion of a contingency for financing, proof of funds qualification from a lender, sale of buyer's property, etc. So, this is how, as listing agents, we are going to confirm a buyer's financial capability within the terms of the offer. We're going to request a proof of funds if it's a cash offer. We're going to make sure we've got that pre-approval letter if it is being financed. So, dispute resolution. The parties understand that if there's a dispute about the listing or an alleged breach and the parties cannot resolve the dispute by mutual agreement, the parties may consider judicial resolution in court, or may consider alternative dispute resolution. Alternative dispute resolution may include mediation and binding arbitration should the parties desire to submit any potential dispute to alternative dispute resolution. It is recommended that the parties add such in additional provisions or in an addendum. So, this is something that I kind of make a joke of, not make a joke of, but make light of. Just, if there's a dispute about this listing contract, this spells out that how we can resolve it. But, again, back to business practices, if there's it's very rare that we as a firm are going to keep somebody in a contract, right? 1 second, just gonna make sure everybody's muted. Fair housing, seller and the firm and its agents. So sorry. Agree that they will not discriminate against any such prospective buyer on account of race, color, sex, sexual orientation as defined in Wisconsin statutes, disability, religion, national origin, marital status, lawful source of income, age, ancestry, family status, status as a victim of domestic abuse, sexual assault, or stalking, or in any other unlawful manner. So I don't go through this line by line, but again, just a quick, in the state of Wisconsin, we cannot discriminate against any of these protective buyers or protected classes. Of course. All right, now we're getting into the meat and potatoes of the service agreement between a firm and a client. So we're getting into the duties that we owe to all customers and clients in a transaction, additional duties that we owe to clients of a transaction. So a client would be a seller who's listed, who has entered into a agreement with our firm. And then we're going to get into multiple representation. And I would say that these next sections are the heart of the contract. So disclosure to clients. So beginning at line 68, under Wisconsin law, a brokerage firm and its brokers and salespersons owe certain duties to all parties in a transaction. So Mr. Seller, for all clients and customers of a transaction in the state of Wisconsin, we owe the duty to provide brokerage services to you fairly and honestly, the duty to exercise reasonable skill and care, the duty to provide you with accurate information about market conditions within a reasonable time if you request it, duty to disclose to you in writing certain material adverse facts about a property, duty to protect your confidentiality, duty to safeguard trust funds, and the duty when negotiating to present contract proposals in an objective and unbiased manner. Moving on, because you've entered into an agency agreement with the firm, you are the firm's client. A firm owes you additional duties to you as a client of the firm. So the firm or one of its agents will provide at your request information and advice on real estate matters that affect your transaction. The firm or one of its agents must provide you with all material facts affecting the transaction, not just adverse facts. Firm and its agents will fulfill the firm's obligations under the agency agreement and fulfill your lawful requests. Firm and its agents will negotiate for you, and firm and its agents will not place their interests ahead of your interests. If you become involved in a transaction in which another party is also the firm's client, multiple representation comes into play and different duties may apply. We'll get into that in a minute. So I do quickly list all of the duties that we as a brokerage real estate salespeople owe to everybody in a transaction. I do want to point out just to comment on different circumstances that you might come across. The biggest one to me under the common duties are the duties to exercise reasonable skill and care in providing brokerage services to you. So I just want to use this as an opportunity just to remind you guys that if you are called upon to service a listing in an area outside of your market, this goes against your license, in that we need to make sure that we are handling our clients with reasonable skill and care. And so if you are attempting to take a property that's outside of your market, we are not providing that duty to our clients, right? If we cannot service it well. So biggest example of that, I've had a few people this year, down here wanting to list property in Door County, for example. And, the question becomes, A, do you know that market? B, are you, in a location that you can service the listing well? Are you able to get to the property in a timely manner? So we're always going to encourage you or require that you either partner with somebody in that area. I know ideally that could be a relationship that you could work out where both of you could handle, an agent up in that market area could handle, the nuts and bolts of the contract. And then maybe you have a piece in, you can offer services in another way. Or it would just be a straight referral to that other agent in that area. Okay. Any questions on that? Okay. All right. So moving on to additional duties. So the whole reason why a seller would want to pay for our services? A, marketing, obviously, but then B, the ability to receive this full scope of these brokerage services, and that is the ability to receive your advice, get your opinions, and the ability for their agent to negotiate for them. So this is, the reason why why sellers would call upon a realtor to help them, assist them with a sale of their home, right? So very important. Okay, multiple representation. Any questions on additional duties? Katie? Okay. All right, multiple representation and designated agency. So multiple representation happens only when a buyer client would come forth with an offer from the same firm, with it being represented by an agent from the same firm. So I'm going to go back to the example that I used last time we did this training. I've got a property listed. Joni brings a buyer client to the transaction, comes forth with an offer from her buyer client. And now we are in a multiple representation situation. So I have a contractual relationship with my seller. She has a contractual relationship via buyer agency with her buyer. And both parties need to consent to this. And then there are a number of ways that a client can consent to this relationship. So I'll just go ahead and read what the language is on how a multiple representation relationship exists. If a firm has an agency agreement with more than one client who was a party in the same transaction, if you and the firm's other clients in the transaction consent, the firm may provide services through designated agency, which is one type of multiple representation relationship. So designated agency, which we're hoping 9.9 times out of 10 is what the case is going to be. So designated agency means that different agents with the firm will negotiate on behalf of you and the other client or clients in the transaction, and the firm's duties to you as a client will remain the same. Each agent will provide information, opinions, and advice to the client for whom the agent is negotiating to assist the client in negotiations. Each client will be able to receive information, opinions, and advice that will assist the client, even if the information, opinions, or advice gives that client advantages in the negotiations over the firm's other clients. An agent will not reveal any of your confidential information to another party unless required to do so by law. So this multiple representation with designated agency means that a good analogy that I got from Joni is I, listing agent for my seller client, I'm going to get into that boxing ring with Joni, who is representing and negotiating and fighting for her buyer client. And we are the designated agents for each of our clients. And we are still able to, under this designated agency option, give the same duties that we have been paid for. So that duty to negotiate, that ability to give advice and opinions, and able to service our clients to the best of our abilities. And the reason why we're being hired to begin with, right? So we are very much want to make sure that everyone is able to make sure that their clients are picking this designated agency option when it comes to multiple representation. The other options are, in this same scenario, multiple representation without designated agency. So if a client does not consent to designated agency, and they have the option to do that, they have the right to do that. That means that we as agents have lost our ability to give those extra duties, that duty again to negotiate, the duty to give advice and opinions. And Joni and I in the same scenario would have to act as neutral parties and basically just communicating information with one another between parties and back to our clients. But
I have a
not,
question.
yeah.
How often, percentage wise, and this is just best guess, of course, does that happen that it's not authorized?
Not very, I mean,
Yeah.
no, not very often.
Okay. It seems like
Um,
they wouldn't, it seems like people wouldn't want to do it. And I'm sure their reasons are out there, but
where we have seen it done, and I don't even actually I almost want to get away from even describing this scenario. Is if an agent has a seller client and they
Mhm.
happen to have a buyer client who wants to write on the property. They want to have the ability to write the offer. They would need to become neutral and have both parties consent to multiple representation without designated agency. And they're just acting as a paper pusher between the two
yeah,
parties,
yeah,
we discourage that. Again, just help protecting the public and making sure that we are providing the full scope of our services.
Mhm.
We do think that it's best to, if there is a buyer client involved, that you as a listing agent have brought to the table. If you are able to have another agent write that offer, and then act in a designated agency capacity,
Mhm.
I think is the best way for that to be handled. Again, so that you are giving the full scope of services, providing full scope of services to these clients.
Yeah, okay.
But with full disclosure, sometimes it's a cut and dry situation where it's not necessarily, it's fine to leave it as a neutral, acting in neutrality.
Can I ask a question about, say you have buyer agency with your buyer client and you've got the listing with your seller client, and you don't want to work both sides of the transaction. You do want to have another agent in the firm work with the buyer's offer. What do you do with the signed buyer agency?
You would amend both. Well, no, I'm sorry. No, you don't have to do anything. I mean, you can just call in another agent and they will write the offer. The agency contracts are with the firm. So we don't need to amend, and I hope I'm answering this correctly for you. We don't need to amend the buyer agency agreement to reflect the fact that another agent is writing
Okay.
the offer. You can just leave it alone.
Okay, so any other agent in the firm, because it's the firm that is ultimately caring for the client. Any
Yes.
other agent can write any offers or anything like that. Doesn't have to be me as the agent.
Right.
Okay. So
Right.
I was wondering if they would have to sign another buyer agency with that other agent, but that answers it then. Thanks.
Yep.
I remember a training that I was at a long time ago when this was all kind of new to us. And the speaker who was training us said, okay, how many in here have a client and buyer agency? And a lot of us raised our hand and he goes, no, you're all wrong. Your brokerage has a client and buyer.
Yeah, good reminder.
Something that we have to keep remembering.
Yes. So that's without designated agency. And, again, both parties, the way that you can think about without designated agency is neutral parties in the transaction. Complete rejection of multiple representation. So I since the last time we trained on this, I think I saw my first example of someone who rejected multiple representation altogether. And so thus rejecting any KW agent from bringing a buyer, and it was an attorney seller. So makes sense. So if a seller or client, I mean, buyer client too, if a seller rejects multiple representation altogether, that means that they are, alienating a buyer pool of people who are going to come from Keller Williams Realty. So that needs to be explained to them that no, well, let me backtrack. Any buyer client with Keller Williams would be prohibited from writing on the property. That doesn't mean, though, that a Keller Williams agent who is acting on behalf of the seller when they write the offer, who has a buyer customer, they would still be able to write an offer on the property. But any
But
buyer, what? I'm sorry, what did you say?
But not negotiate for that buyer.
Right, but not negotiating for that buyer. So that attorney who rejected multiple representation, I mean, they know how these things can play out, and so we're sticklers on it. And unless that offer from that KW agent, unless that KW agent is acting on behalf of me and writing the seller and writing on the seller's behalf, then I don't want to see an offer that's written in a buyer agency capacity. So then moving on, it gives the explanations of what designated agency is before kind of getting into the options for the client to choose. Excuse me, I gotta admit somebody here. But then it spells it out in an easier manner here on lines 113, 115, and 118. So your client will check one of the following. So the firm may represent me and the other party as long as the same agent is not representing us both. So that's multiple representation relationship with designated agency. The same firm may represent me and the other party, but the firm must remain neutral regardless if one or more of the different agents are involved. So multiple representation without designated agency. The same firm cannot represent both me and the other party in the same transaction. I reject multiple representation relationships. So this is where you will indicate what they consent to. Note, all clients who are parties to this agency agreement consent to the selection checked above. You may modify the selection by written notice to the firm at any time. Your firm is required to disclose to you in your agency agreement the commission or fees that you may owe to your firm. If you have any questions about the commission or fees that you may owe based upon the type of agency relationships you select with your firm, you should ask your firm before signing the agency agreement. I don't think I've ever seen a case where, depending on what the client consented to in terms of multiple representation, that the commission would change. So, so in practice, I think the best way to explain these things is using examples. Right. So again, I would, use another agent in your office that you could use as an example, the same way I just did with Joni and I, but, Mr. and Mrs. Seller, so multiple representation. So the way that this, or what this means is if another KW agent brings a buyer client, you need to consent to that other agent acting in the same way that I am able to act for you. So I have the ability to negotiate and give my opinions to you, give advice to you, negotiate on your behalf. That buyer agent also has those same capabilities with their buyer client, and you need to consent to that. So any questions about that? I always like to point out that we have a video on multiple representation in our YouTube channel. that we spent, I think we spent a half an hour on that, along with the concept of right to cure. So if you want to revisit that, I would definitely go to that video.
Is that just the Keller Williams or is it yours specifically?
Yeah, it's the Keller Williams YouTube channel.
Okay,
So,
just wanted to check. Thank you.
yeah.
And then in February, I'm going to do Monday contract training on buyer agency again.
Perfect. I will be there.
Yeah, we've, I think multiple representation and the concept of right to cure are the hardest to explain to a seller or to clients. Sub-agency. Your firm may, with your authorization in the agency agreement, engage other firms to assist your firm by providing brokerage services for your benefit. So a sub-agent is that co-broke company who could bring another buyer or bring a buyer to the transaction. Please, just a checkpoint for the seller, please review this information carefully. An agent can answer your questions about brokerage services, but if you need legal advice, tax advice, or professional home inspection, contact an attorney, tax advisor, or home inspector. I think it's a good checkpoint for us to just remind everybody that we're not attorneys, and if they need, and tax advisors, if they need questions answered, that we will need to refer them to more capable parties. Confidentiality notice to clients. So the firm and its agents will keep confidential any information given to the firm or its agents in confidence, or any information obtained by the firm and its agents that a reasonable person would want to be kept confidential unless the information must be disclosed by law, or you authorize the firm to disclose particular information. The firm and its agents shall continue to keep the information confidential after the firm is no longer providing brokerage services to you. Following information is required to be disclosed by law: material adverse facts, any facts known by the firm and its agents that contradict any information included in a written inspection report on the property. To ensure that the firm and its agents are aware of what specific information you consider confidential, you may list the information below. I think Joni and I made a joke about this last time that, if it's confidential, we don't often see anything written in these lines. So, and, all that section can be a one-liner to a client. We owe you confidentiality in the transaction.
Real quick, if there was something confidential, could you give an example of what you would put there? Even though I know you typically don't, but just so I can wrap my brain around it.
Right. I think it's like I've seen divorce situations before that couples didn't want to be revealed. That is the one. Yeah.
Yeah, that's fine.
All right. What time is it here? 2:47. Okay, we're good on time. Cooperation, access to the property, or offer presentation. So a provision for the seller: parties agree that the firm and its agents will work and cooperate with other firms and agents in marketing the property, including firms acting as subagents. Cooperation includes providing access to the property for showing purposes and presenting offers and other proposals from these firms to the seller. Note any firms with whom the firm shall not cooperate, any firms or agents or buyers who shall not be allowed to attend showings, and the specific terms of offers which should not be submitted to the seller. It's rare, but we have seen sellers who have refused to allow certain agents into their properties, or who, it could be a contentious relationship that they had with an old firm. Or an old, firm and its agent. So just know
I have
that.
a question.
Yeah.
In this area, like say a homeowner has like a restraining order against somebody, would that be a name you'd put in there?
Okay. Yeah, it would be any buyer who you do not want to, yes. You would put that person in there. Okay.
Yeah, I think one of the things to talk about in this situation, and I've seen many not many, but several examples of it, to explain to the seller, yeah, you may not want this person through, or you may not want this agent to come through, or you may not even want this firm to come through because you had a bad experience with them. But all you're doing is diminishing your odds of finding the buyer. And you may have those feelings, but this is a business contract that we're in, and the aim is to sell your house. So sometimes you can talk them out of that, but a lot of it's kind of vengeance.
Yeah, 100%.
I have a question about our fiduciary responsibility for line 156 and 157. If they name someone there, I mean, what capacity do we have to prevent those people from entering the property? And are we going to be on the line for, if they did come on the property and we couldn't prevent it?
Right. I think in situations that I've experienced, basically the listing agent or the listing agent and the broker, the manager, can call that other company and agent to give them a heads up that this is the request that they have. And a lot of times it's taken like, well, I expected that kind of thing. They weren't surprised. If it's a person of the public that they do not want to let in, that can be a little more delicate because agents can kind of roll the stuff off their back, but sometimes somebody in the public may not. And that you sort of watch showing time. You can put a note in showing time to alert the listing agent if that person wants to see it, but a lot of times you don't know who the buyer is. So you only know who the agent's requesting the showing, and you don't know what buyer they're bringing in. So that becomes a little more confusing. But usually it's sorted out.
Mhm.
Might be some flare up, but
Does that help, Tammy?
A little bit. I'm just wondering, like, can the seller come after us as agents if they find out that someone they didn't want to come in onto their property ended up coming onto the property because we didn't prevent it somehow? I mean, are they gonna have any right to sue us or for damages or anything?
I mean, anyone can sue anyone for anything at any time. So, I mean, I guess it's just our ability to demonstrate that we prevented the visit from happening to the best of our ability, right? So, I guess it's a hard one to answer. I don't have an example to call upon to say what happened if, when that situation happened. So,
another way of doing this, if you actually have a person that's listed, not an agent or firm, but a person, then you should probably change showing requests to all showings through the listing agent. And so then the listing agent has that extra duty to talk to the agent who wants to show the property and then ask them outright the name of their buyer to make sure it's not the person that they can't come in.
Okay.
Yeah, that's a very good point. If there's anything like that, just make sure you switch it to showings to go through you. Okay, we'll just finish out this page and then we'll start on page 4 next week. So exclusions. So exclusions to a property. So all persons who may acquire an interest in the property who are protected buyers under a prior listing contract are excluded from this listing to the extent of the prior firm's legal rights, unless otherwise agreed to in writing. Within 7 days of the date of this listing, seller agrees to deliver to firm a written list of all such protected buyers. Note, if seller fails to timely deliver this list to the firm, seller may be liable to the firm for damages and costs. So if you are in a situation where you are taking over a listing from a prior firm, we need to collect, or the seller needs to deliver, a protected buyer letter to you. So under the terms of their prior agreement, if the prior listing firm was unsuccessful in a sale of the property, any buyer who saw the home or wrote an offer on that home during the term of that listing contract becomes what's called a protected buyer. So if you take over a listing and that a buyer who had previously saw the home under the agreement of the old listing firm, that commission would be owed to the prior listing firm. So it's very important to know. If a buyer comes forth and wants to write an offer who had previously seen it, then we would step away and the seller and their prior agent and firm would handle negotiations from that point. So if you do know that it was listed prior to you are taking over the listing, or prior to us entering into a listing agreement with them, I would be proactive and ask for that letter. Right, Joni?
Right.
Yeah, okay. So they do need to deliver it to us though. So the way that process works is the old listing firm would have delivered a letter to them with those protected buyers, then that seller now needs to communicate that with us. So that's one example of a protected buyer, or one example of an exclusion. There's another example, and the following other buyers, starting at line 163, a seller can name other potential buyers who are exclusions to a contract. So a biggest example of that would be maybe they have a friend who had expressed interest in purchasing their home, and by the time they were ready to list, they hadn't pulled the trigger and wrote an offer. So that friend could be named here. Maybe it's a neighbor who had expressed interest in buying the home. But if the seller chose, the seller could ask that these buyers who they have started negotiations with be excluded from this listing, meaning that if they come forward and write an offer, the seller would not owe us a commission. That being said, we would want to make sure that we would put a timestamp on those kind of buyer situations. So moving on, or continuing on line 164, the following other buyers, you'll name them there, are excluded from this listing until, and then you'll enter a certain date here. These other buyers are no longer excluded from the listing after the specified date. So the reason why you would want to put a timestamp on that is oftentimes our marketing efforts could trigger that buyer to come forward and want to end up making an offer on the property. So what we see is common. I think Joni gave the advice last time, don't make that date any more than a week. That neighbor who had expressed interest, that friend who had expressed interest, has a week to decide whether or not they want to write an offer. But if they want to write an offer on, day 8, it could be argued that our marketing efforts are what prompted them to want to make an offer. So we suggest making that a very tight window of time. Any questions on that? Okay. Well, that's a good natural stopping point. So we got through the first 3 pages. We'll continue on 4, 5, and 6. It will go much faster. Last page is pretty clear, just delivery lines and all of that. So come with questions. I know that all of our trainings in the past couple of weeks have been pretty listing focused. So, if you just have general questions on, the listing contract or, listing presentations in general, we can help answer those. Okay.
Thank
Nice
you.
work.
Thank you guys.
Yes, thank you.
All right. Talk to you
Have a
soon.
great day.
Yeah, you too.
Bye-bye.
Bye.
Bye. Bye.
Bye.
All right. So we're on to our next meeting.
We're on to the next meeting. Hey, really quick. Actually, you know what? We'll get off this channel since it's still recording. Let me just call
Okay.
you really quick. Okay.
Okay, good.
Right.